Hi, I'm Dave Champion, and welcome to another edition of the Dave Champion Show. Well, before we get going, I want to let you know that I've just completed a new article that is posted on the blog, the address of which should be right here. So if you want to go and read the new article, I encourage you to do so. It's about the question as to whether we, you and I, are giving liberty, not just demanding liberty. Also, if you're on Facebook, you can go to the media page. Just all you have to do is search for Dave Champion Media. That's the name of the page. And then under the notes, the same article is posted there as well, so you can get to it. All right, first article up. I have talked repeatedly about the issue of police violence. And it would be great if it was something I could talk about and never have to talk about again, because it wouldn't be a problem again and again and again and again. Unfortunately, we have what I would consider to be an epidemic of inappropriate, illegal, criminal police violence without accountability in this country. And I want to talk a little bit about this. There was a police officer by the name of, Brian McGee. He is a Fullerton police officer. And do you remember back when Christopher Dorner, an LAPD officer, had killed a couple of LAPD officers, and then he was on the run? And all of law enforcement in Southern California was rabid to catch Christopher Dorner. And I certainly understand why they would want to. However, being rabid about catching Christopher Dorner doesn't give you the right to shoot other innocent people who are not Christopher Dorner. All right, so just this past week, the Los Angeles County District Attorney Jackie Lacey, I want to make sure I get her last name correct, announced that her office was not going to prosecute Officer McGee from the Fullerton Police Department. So what did Officer McGee do? Well, let's put this into context. First of all, we talked about the Dorner incident. There was a manhunt on for Christopher Dorner. Just before this incident with Officer McGee, other officers a few miles away had stopped a truck that looked like Dorner's truck, and without any cause, that's the critical element, without any cause, they had fired multiple rounds through the back of the pickup truck wall into the two Asian ladies sitting in the truck. Now, Christopher Dorner was a large, muscular, shaved-headed black man, and these were little, tiny Asian women, and LAPD officers fired multiple rounds through the back of the pickup truck into these ladies. So that's the context. Moments later, Officer McGee sees a truck on the freeway. The make and model is the same as Christopher Dorner's, but it's a different color, right? So what does Officer McGee do? Well, he smashes his patrol car into the car of David Perdue, a surfer who was just heading down to the beach to do some surfing. And here he is driving down. He's thinking, he's going to catch some great waves, have a good time. Smash! Officer McGee smashes his patrol car into Perdue's truck. Now, if that isn't bad enough, then Officer McGee exits his vehicle and starts pounding rounds into David Perdue's truck. Okay? Critical element here. Never gave David Perdue any verbal commands. Smashed into Perdue's truck, jumped out of his car, and started hosing down Perdue's truck with his handgun. Okay? Now, fortunately, McGee was as bad a shot as he has bad judgment, because none of his rounds, fortunately, hit David Perdue. So the truck is a different color than all of the cops know that Christopher Dorner's truck is. But let's say, for the sake of argument, that Officer McGee was amped up and the difference between this color and that didn't really register. Well, I'll even give him maybe a little bit of credit and say he's possibly a skosh colorblind. I'm trying to give this guy a benefit of the doubt, right? which he doesn't deserve, but I'm trying to do it for illustrative purposes. But we know what Christopher Dorner looked like, this big, massive, muscular, shaved-headed black man. Well, Perdue is 100 pounds lighter, a full head of hair, and white. And yet, McGee pounds rounds into his car under the belief it's Christopher Dorner. So, what are the possible charges the Los Angeles District Attorney's Office could have brought? Well, you certainly wouldn't want to bring murder charges because Perdue wasn't hit. You wouldn't want to even bring, I don't think, attempted murder charges because I think it would be very hard to convince a jury that Officer McGee intended to kill the wrong man. He said, gleefully, I'm going to use this as an excuse to kill the innocent. I don't think a jury would buy that. I wouldn't buy that. I don't think that's at all what happened. How about second-degree murder? This is where it's not premeditated, but the same sort of, instead of hours ago saying, I'm going to kill an innocent person, now you say it spur of the moment. I have an opportunity. Now I get to do it. I don't believe that's what happened either. So, second-degree murder, I don't think a jury would convict them. Now, let's take a look at what is called third-degree murder, often referred to as manslaughter. Now, manslaughter, depending on what jurisdiction you're in, it has several flavors and it has different boundaries, and I can't get into all that. It changes state to state. So I'm going to give you the broad strokes on this. There is a version of manslaughter. The law has different degrees and qualifications for these different elements that comprise manslaughter. There is one called criminal negligent manslaughter. Let me read you the definition. Now, I'm saying he should be tried for attempted manslaughter, not manslaughter. So the fact that it's talking about death, we're talking about attempt to kill, right? It occurs where death results from serious negligence or, in some jurisdictions, serious recklessness. So, there is a charge that is appropriate for Officer McGee of the Fullerton Police Department, and it is criminally negligent manslaughter. In other words, is there anybody on the planet who imagines that Officer McGee's actions were not seriously negligent? Okay? Is there anybody on the planet who would imagine his actions were not seriously reckless? Yeah, I don't imagine there is anybody who would say that, except Officer McGee, of course. So there is a charge. But why doesn't Los Angeles County District Attorney Lacey want to bring the charges? Well, it's simple. Government does not hold employees of government, especially enforcement individuals. It doesn't have to be cops. There's all sorts of enforcement that goes on in the government. The government doesn't want to hold its enforcement agents to the same standard as regular people. As an example, let's say there's just some other California or LA area resident at the same time that this Christopher Dorner thing was going on. And he says, man, that Christopher Dorner guy, he's killed people. If I see that guy, yeah, I'm taking him into custody or he's going down. Oh, let's say this guy has a legitimate concealed carry permit in Southern California. This is a fantasy story, I know. So he sees a truck that looks like Dorner's, but it's a different color. And inside that truck is a guy that's nowhere near Dorner's size with a full head of hair, and he's white. And the guy says, but that truck could possibly, maybe, I got the color wrong, that could be Dorner. So he pulls out his weapon, boom, 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 he caps a bunch of rounds into the truck. What do you think would happen to him? He'd probably be spending about the next 10 to 12 years in a state penitentiary for attempted manslaughter. Now, one of the distinctions about manslaughter is that you don't need to have mens rea. In other words, you don't have to show, criminal intent. All you have to do is show that it was seriously negligent or serious reckless, which I think is clearly the case here with Officer McGee. The point being that when we keep talking about needless law enforcement violence, part of what we're talking about is that people like D.A. Lacey simply, that's a green light. Okay? What she's doing by saying she's not going to prosecute McGee, what she's saying is to the cops in the Southern California area, at least in the Los Angeles County where she's in control of prosecution, what she is simply saying is, if you have the color wrong, the race wrong, the stature wrong, the overall appearance wrong, and you hose somebody's car down with a gun, good to go. This officer isn't going to do anything to you. God bless you, carry on. That's what she's saying. Now, I'd like to tell you that this is the only such case of these things going on, but we know it's not true. One of the articles in the news this week was a reserve police officer beat a 4-year-old child so badly, the 4-year-old child had to be emergency airlifted to an ICU unit. Okay? Fortunately, there was a little different outcome as far as the officer was concerned. His own agency then, 3 days later, did a massive violent SWAT entry onto the home, used an armored car to break through his fencing, used flashbangs in the house, and took him into custody. He's being held on $1 million bail, and he's going down. But that's because he hurt a child, and it was not involved in an official police function. Had he beat that child, that 4-year-old child, senseless and put him in the hospital for official reasons, well, we don't know how the outcome would be. Now, when we come back from the break, I'm going to tell you another story. And this is about a case out of Orange County, California. And I think it is, I know it is far more egregious than the story that I just shared with you about Fullerton Police Officer McGee. Because, first of all, the person that the violence was perpetrated against is dead. He died from the violence. The violence was completely uncalled for, totally unnecessary. And these two officers did get tried. And, well, they're walking around today completely free without consequence. How's that for accountability? I'm Dave Champion, and I'll be back right after these messages. All right, we're back talking about inappropriate, illegal, criminal police violence. And I want to share with you another story. There was a homeless schizophrenic man by the name of Thomas Kelly. And he's now dead. He's dead because he was beaten by officers Manuel Ramos and, I want to get this last name right, Jay Cicinelli. Okay? They got a call concerning a homeless person, so these two officers roll up and they ordered Kelly to sit on the curb with his hands on his knees. Now, this is a mentally disabled person with diagnosed schizophrenia. And he did not stay sitting on the curb with his hands on his knees. Okay? I've dealt with this plenty of times. Especially, a lot of homeless people are what the law enforcement circles often refer to as EDP, emotionally disturbed persons. So when you come in contact with a homeless person as a police officer, there's a high expectation that they're going to be an EDP. So to expect a homeless person to act rationally, you understand that a certain percentage of homeless people are EDPs, and they're not going to act rationally, and you approach the situation, if you are a rational police officer, you approach the situation understanding that and understanding that irrationality is irrationality, and that irrationality, you always have to be careful for something that can be or would turn into a dangerous situation, but there's a difference between irrational conduct and that which is a danger to the officer. Okay? The ethos today is if I don't get compliance, that equals danger. And that is not true. That is not true at all. But that's today's modern law enforcement ethos. If I demand X and you don't give me X, you are immediately a threat to my safety, which is, frankly, bullshit. Okay? I want to put a very fine point on that. Okay? So, Kelly does not keep his hands on his knees. There is a little bit of uncertainty as to what transpired immediately thereafter, but we know that Kelly was non-cooperative with the request to keep his hands on his knees. Now, there was a 33-minute video shot of this. By the way, if the video had not been shot, we wouldn't be having any of this discussion, because these police officers would have said that the guy attacked them, that he was out of his mind, he was like, crazed on drugs and they couldn't stop him, and they just barely got away with their lives. And if there was no videotape, that would have been the end of the story and nobody would have known better. But there was a videotape. And I'm here to tell you, by the way, always tape cops. Always film police officers. Okay? A New York detective once stated that some of the best written fiction in America appears in police reports. That's from a retired cop, right? Some of the best written fiction in America appears in police reports. That's somebody who did an entire career and retired from law enforcement making that statement, not me. Always film. If you see them over there doing something that looks like it's going to get nasty, film it, because there are significant odds that it's not going to get written up the way it went down, but you'll have the video. Okay? This is how we stop this. Okay? Video. So there's this 33-minute video. So how much of a threat was Kelly? Well, I'm going to tell you how much of a threat he was. He was so much of a threat that Officer Ramos got out latex gloves, calmly put his latex gloves on. Clearly, he's not fighting for his life. He stood there calmly putting on his latex gloves. Then he said to Thomas Kelly, after he got the gloves on, "See these fists?" This is a quote right off the tape, by the way. "They're going to really F you up." Okay? How much of a threat was there to the officers if he had time to casually put on his latex gloves and then threaten Kelly with the violence that Ramos was intending to reap upon him? The answer is there was no threat at all. There were acts of disobedience by Kelly because he was schizophrenic, mentally disabled, but it wasn't a threat to the officers. The officers wouldn't have had the time to act this way. Okay? Now, for the next 9 minutes, by the way, additional officers showed up at the scene. For the next 9 minutes and 40 seconds, 6 police officers beat Thomas Kelly. 9 minutes and 40 seconds. For those of you who maybe in your youth you used to get in fights, or you're involved with the martial arts, or maybe you just watch these UFC or MMA type things, right? You understand, if you are fighting for real out on the street, 30 seconds can be an eternity. If you are fighting in something like UFC, you know how long 2 minutes can be. Imagine 6-on-1, 9 minutes and 40 seconds. Okay, show of hands, how many people believe, say, 3 minutes into this, that Thomas Kelly was a threat to those 6 police officers? Anybody? It's absurd, right? In addition to that, Officer Cicinelli tasered Kelly twice in the face. Now, that's not police protocol. You don't taser somebody in the face. Kelly was on the ground. He clearly could have shot the barbs into Kelly's torso. He chose the face. He targeted the face. This was torture by police officers. So, Ramos beat Kelly with his fists, and then I guess when he started to tire, he picked up a baton, police nightstick, began beating him with a nightstick. During the 9 minute and 40 second beating, Kelly cried out 102 times. Here are some of the things he said. He's crying this out while he's being beaten to death. "Sir, please, okay, okay." He said that 30 times. Okay. Every cop knows that means they're surrendering. Whatever the officer thought they were doing, they're done doing it. But the beating continued. "Help me, God," he screamed out 26 times. "Dad, help me. They're killing me." His father was nowhere around. He's not right in the mind. "Dad, help me. They're killing me," he yelled out 31 times. The beating continued. All 6 officers beating him. Well, this is one of the cases where the district attorney did prosecute. And the defense argued, the defense being representing the officers, of course. You got to get this. Are you ready? That the officers were in fear and they were defending themselves. 6 against 1 for almost a 10-minute beating. Does anybody on the planet believe that these officers were defending themselves and in fear for 9 minutes and 40 seconds? 6 against 1? Also, the defense contended they were acting in accordance with their training. We'll talk about that in a little bit. I asked if anybody would possibly believe that these guys were in fear. Yeah. 12 people. 12 people believe it. They're the 12 absolute idiots who were sitting on the jury who acquitted both Ramos and Cincinnati. Yeah. A jury acquitted them. Unbelievable. I say on this show repeatedly that we are responsible for these killings and these beatings, and these unjustified taserings, and the unjustified incarcerations and so forth. Why are we responsible? We're responsible because we here in America have cop worship and we have military worship. And in reference to this case, obviously the relevant part is cop worship. These 12 Americans sit on the stand. Now remember, police officers testify for a living. It's not something they do once. They do it all the time, again and again and again and again. And oftentimes they go under oath and lie. They are, most of them, not all of them, most of them have lied under oath. They are professional liars. And then they realize their very lives are at stake. You think they're going to lie? So they get up there with these big doe eyes and they say, I was terrified. I was in fear. It was terrible. I thought I was going to die. I never wanted to harm that man. I didn't want to touch him. I didn't want to hurt him, no less kill him. I was just trying to, I wanted to go home to my wife and my kids. That's all I wanted. If you were in my shoes, you would want to go home to your wife and kids too. It's terrible, terrible, traumatic. I mean, it's traumatic for me to have gone through this. I never wanted to hurt that man. And it's all BS. He slapped on the gloves and said, "These fists are going to F you up," and then proceeded to make good on his promise. That sounds like somebody, I really didn't want to hurt him. I was just trying to protect my life. The people who are responsible for this happening again and again and again and again, who may be responsible for you getting beaten, your spouse getting beaten, your child getting beaten, your adult child being beaten to death just like Thomas Kelly was. The fault is yours because you get in the jury box and you believe these guys because America has cop worship. Do you know how many cops are convicted even when the DA has the testicular fortitude to take them to trial? Do you know how many are convicted? Damn near zero. If you don't want to be beaten, start doing the right thing. I'll be back in a moment. All right, so we've talked about the case of David Perdue having his car shot up by Officer McGee. And, you know, he could have just as easily died. It's just fortunate that McGee can't shoot. We've talked about Thomas Kelly being viciously and, in my opinion, I know these two officers have been acquitted, but in my opinion, criminally murdered. Okay. A friend and a viewer asked me recently why law enforcement has gotten so heavy-handed. Because this kind of thing, cops back in my day, they were, believe me, not opposed to using violence when necessary. But these kind of 10-minute beatings where the person dies didn't happen. The reason it didn't happen is, somebody who was a real bad guy, not somebody who was emotionally unstable, mentally unstable. Somebody who was a real bad guy, depending on what he did at the moment when they were trying to take him into custody, well, I'm going to tell you the truth. He might take an ass whooping, but not like this, okay? And then they got arrested, handcuffs got put on them, they got taken down to jail. If they needed medical care, they got it, and off to trial they went, and that was the end of the story. People weren't beat to death mercilessly on the street. So what's different today? Well, I've got some bullet points here that not in any particular order. Cowards. Law enforcement has a lot more cowards in it than existed there 30 or 40 years ago. And let me explain what I mean by that. 30 or 40 years ago, if you wanted to be a cop, it's because you wanted to be a cop. And back then, being a cop was not glamorous. I mean, the big television show about cops was Adam 12, all right? There was nothing sexy about that. So if you wanted that job, you had a fairly realistic frame of reference as to what the job actually was, and you understood, you could look at all the various occupations that were out there, say, of all the occupations that were out there, I choose cop. Knowing it wasn't glamorous, knowing it wasn't high paid, knowing it was long hours, knowing there was going to be violence and you might be the one receiving the violence. Everybody knew that. Today it's different. Today, violence wreaked upon a police officer is almost unheard of. That's very appealing to bullies and cowards. Okay? Perfect example would be Thomas Kelly. 6 officers beating 1 man for 10 minutes. Okay? Those are cowards doing that. And there's absolutely no excuse for it. I'm going to cover in a minute how the training has changed a bit, which tends to take officers down that road a bit. But 10 minutes, give me a break. Okay? That's just viciousness and cowardliness. All right, so, and also today people join for all sorts of reasons. The pay is significant today, where 30 years ago it was not. Today there's all sorts of cop shows, and cops are the heroes, and they do these amazing, fantastic tasks. And boy, to be a cop today is considered a pretty sexy thing. And boy, especially if you're a guy, you're going to get a lot of the honeys. It's a whole different game today. It's not just being a blue-collar working man like it was 30, 40 years ago. It's something considered a lot sexier today. That means the people who don't necessarily really want to be cops, they just want the sexy part of it, gravitate towards law enforcement. The money's pretty substantial these days. The benefits are pretty substantial these days. And despite all the crap that they talk about how dangerous the job is, okay, been there, done that, it ain't that dangerous, it's not even like the top 50 or 60 most dangerous jobs in the country. Not even close. Okay? So that's just all hooey. And then a lot of cops, they join because they want to do other things within the agency. They don't want to work on the street. They want to do other things. So they join. They do as little time as they can on the street. They're not real cops. They have other agendas. Okay? So we got a lot of these cowards, guys that really aren't cops in their hearts and souls, and we see what happens. They turn into petty tyrants and thugs. Second reason, inappropriate application of something called qualified immunity. What qualified immunity means is that a police officer in a civil action against them can be, by the court, dismissed from the case in their personal capacities, dismissed from the case because the defense attorneys came in and made the case that what they were doing was reasonably within the scope of their job, or that they were following training they had received in the academy, or training they had received after leaving the academy, incremental training throughout their career, or training in their first year from their field training sergeants and so forth. So if they argue that the officer's action was in accordance with the department policies or the training they'd received, or was properly within the scope of their employment, then the court will say, we're not going to hold these guys personally responsible. If they were doing what their department taught them, if they were within department policy, in their personal capacities, we're going to dismiss them from the suit. What that means is when the judgment comes in, let's say it's a $6 million judgment, right? The cops don't have to pay a penny of it. You do. The taxpayers pay 100% of the cops pay nothing. Okay? Just like these officers take the stand, as I said earlier, with these doe eyes, and it was terrible. I was in fear for my life, when they were really just giving somebody an ass whooping. Okay? The same thing happens when their attorneys start making these cases about policies and training. You can twist this stuff, especially if the training took place, say, 7 years ago. You can twist what was said, or your understanding of what was said. Or let's say your partner was at that training with you, and he's accused of the same thing. He's going to verify, oh, no, that's what we took away from the training, that we were supposed to do it this way. There's all sorts of little games and gimmicks that can be played to get the court to say, well, we're going to dismiss you in your personal capacities. What this does, by the way, when cops are constantly, by the way, that's about 98% of cops that are sued civilly are dismissed personally from the suit. It's ridiculous. And what it does is carte blanche. I can do anything I want. Yeah, my department might not give me that next promotion next year. I'll have to wait a couple of years more. Or I might get transferred to a job I don't particularly like within the agency. But nothing really big and important is going to happen to me. I can whoop anybody's butt. I can do anything bad I want. And nothing really bad is going to happen to me. Kind of a carte blanche attitude, and that's exactly what's going on. Unwillingness of the district attorneys to file suit. And there's a couple reasons for that. Some district attorneys, they are very, 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 very pro-cop. They work with cops every day. In their minds, much like police officers today, I have this badge, you don't. Cop, scumbag, okay? Many police officers have that point of view. And some district attorneys have that point of view, that these are my favorite people, these guys with the badges and the guns. The citizens are really the people we have to put up with. So when it comes time to file charges, many DAs they show great favoritism towards law enforcement, which they shouldn't. It is unjust. They are promoting a system that is unjust. And here's the thing. If the public gets fed up and starts shooting cops, really the two people that are to blame for this are cops and district attorneys. Cops for being bad cops, and district attorneys for not prosecuting enough bad cops. Okay? So, and then the other side is many district attorneys have tried to prosecute cops. They got the same outcome as in the Thomas Kelly case, that they're acquitted. How many times are you going to prosecute cops, put yourself on the other side of the fence from the group you work with day in and day out, only to have idiotic jurors with cop worship acquit them time and again? How many times are you going to do that? So sometimes it's not a bad DA. Sometimes it's a DA that says, I'm done. I've tried. This isn't working. The citizens are idiots. These cops are bad. I'm prosecuting. I can't get a conviction. Why bother? And I understand. Changing philosophies of training. Okay? 30 years ago, hands-on was not considered a bad thing. In my mind, it was actually considered, if needed, a good thing. I didn't even let my guys carry batons. Instead, I put them through special schools, martial arts schools, that were very tailored for police officers. So They knew exactly what they needed to do, and having their hands empty and able to use them was the answer, rather than sticking people, which I've never seen as, I mean, it has its application, but very narrow. Today, not so much. Today, police officers are encouraged to keep their hands off of people until the person has complied. So in other words, a police officer might say, knock someone to the ground. Once they're on the ground, that officer is going to say, roll over on your stomach and put your hands behind your head. Okay? If the person doesn't comply, the officer is not going to physically engage. The officer is going to taser them or continue to stick them in the legs. You know, they strike them several times in the legs. Roll over on your stomach. No. Slam them again in the knees. Roll over on your stomach. How about the ankles? Roll over on your stomach. It's called pain compliance. Time is too short to get into how that whole cycle works. But in the old days, especially if you had a partner, somebody didn't roll over, you'd put them in an armbar, roll them over, then handcuff them. I think today cops don't know how to do these things anymore because they're told, don't wrap up physically. Don't wrap up with the suspects. Get them to comply without wrapping up with them. Well, what if you've got somebody like Thomas Kelly who's mentally disabled, who may not be able to comply? The more pain you put on him, the more frazzled his already damaged brain becomes. Why not just put him in an armbar, get him in a wrist lock, roll him over, and handcuff him? Get him in a leg lock and get him on his stomach. Then have your partner get him in an arm lock and handcuff him. I question whether cops even have these skills anymore these days because they're told not to wrap it up with suspects. So what you get is this thing where today, until you're completely compliant, all I'm going to do is beat you. Okay? And then, of course, we get to probably what is in my mind one of the biggest reasons that cops do this is that you sit on a jury, you have cop worship, they look you in the eyes and tell you they didn't intend to do this, and no matter what the evidence is, as I've shared with you in the show, no matter how egregious the evidence is, you say, they were just doing their job, I'm not going to send them to jail. No, they're brutal thugs, you should have sent their butts to jail. I'm Dave Champion, I'll be back right after these words. Welcome back. Let's talk about something a little bit more lighthearted than what we've been discussing. What does the legislature, your legislature of your state, have the authority to legislate upon? Right? If we go back to the Declaration of Independence, which was pre the formation of the states, because, of course, when the Declaration of Independence was signed, we had British colonies, and it was pre the creation of a federal government. And it talks about that the only legitimate purpose for government is the preservation of our unalienable rights, right? So if that's what the Declaration of Independence declared was the whole reason that America started down this path of revolution, can legislatures legislate on things that would suppress your rights? Well, let's take a look at a few things. First of all, let's recap the definitions, the applicable definitions of liberty. Thomas Jefferson's, let me share it with you. Rightful liberty is unobstructed action according to our will within limits drawn around us by the equal rights of others. And my definition? Liberty is freedom restricted by our responsibility to respect the equal rights of others. Yep, pretty clear stuff. Is it then appropriate for the legislature to create laws that prevent us from doing things which, if we did them, harm no one? They don't restrict anybody else. They don't cause anybody to They don't bar anybody from exercising equal rights to our own. We're not harming them. We're not blocking them in the exercise of their rights. Is it within the purview of the legislature then to legislate upon us to stop us from doing things that don't harm anybody else? Well, I think the answer is clearly no. But let's find out if they've actually done some of that. Well, some fun stuff, okay? Massachusetts. Now, many of these, by the way, I should say, are old laws. Nobody would think to enforce them. But two things are true. Number one, they're on the books today. I only chose ones that are on the books still today. And the legislature apparently at one point in time thought it was acceptable to legislate. And remember, legislatures don't get better about this stuff. It's not like they legislate against things they have no right to legislate 80 years ago, and then today they suddenly like, oh, never mind. No, once they have started legislating against things they have no right to legislate upon, that gets worse, not better. Okay? In Massachusetts, you gentlemen cannot have a goatee. Yeah. Oh, I'm sorry, you can have a goatee if you have a special goatee license from the state. Yeah, I kid you not, that's on the book. So I'm going to tell you what I think this law was about back in the day. I don't know, I didn't research it, but when something as odd as that, you have to wonder what. I'm going to tell you what I think it was. I think it was back, say, 100 years ago, gentlemen wore goatees. It was the style. And then the masses started trying to emulate the look of the upper classes. So what they did is they said you cannot have a goatee unless you pay to get a license. And of course, the poor masses couldn't pay the licensing fee or wouldn't just to grow facial hair. So that look was preserved only for the upper classes. I'm going to guess that's what the motivation was. That sounds like legitimate legislation, right? Oral sex. Yes, I said that on TV. Oral sex is illegal in 17 states. Now, I'm going to share with you these states so that you know when you're breaking the law. Alabama, Arizona, Florida, Idaho, Kansas, Louisiana, Massachusetts, Minnesota, Mississippi, Georgia, North and South Carolina, Oklahoma, Oregon, Rhode Island, Utah, Virginia, and Washington, D.C., which of course is not a state. Okay? So if you live in one of those states, whether you are giving or receiving, it doesn't matter. That's how those laws are written. You're a criminal. In Georgia, the punishment for oral sex on the books today, not less than 1 year, not more than 20 years. I kid you not. So help me understand. You're at home with your spouse, and you're having a romantic evening, and you wind up in bed or on the couch or on the kitchen counter, what have you, and you get a hankering for oral sex to give or receive. Okay, help me understand where the legislature gets the authority in the privacy of your own home with your spouse or your date or whatever, I could care less, but back in these days, the presumption, of course, was spouse, that you cannot put your mouth somewhere on your spouse's body, and if you do, you're going to jail. In Virginia, it is illegal to have sex with the lights on. Now, I'm sure the legislators of that day were trying to, I'm sure it was passed after, shortly after electricity became prevalent, and somebody saw somebody doing something, and so the legislators were trying to enforce modesty. Is it the legislators' role to enforce modesty? And who determines what is modesty? By the way, we talk about the legislators enforcing modesty. I will remind you, that's what burqas are about. It's about government, in that case, theocratic government, enforcing modesty. Do you really want politicians making these decisions? Here's another great one for you. These are the states in which you can only have sex in the missionary position. So, ladies, you're out of luck. No doggy style for you. Yes, I said it. If you live in Florida, Massachusetts, Montana, Virginia, yes, they are laughing in the booth, just so you know. Florida, Massachusetts, Montana, and Virginia, if you live there, only missionary position. Sorry, guys. Now, again, okay? The light thing, it's wrong, but I get it. Anything but the missionary position? Okay. Probably, I'm going to guess, probably comes from sex is only for procreation. Therefore, you can't have fun, which means the best way to keep you from having fun is not to allow you to mix it up and just do it one way, always. If you're married for 40 years, 50 years, you do it one way, always. And, of course, no oral either. Okay. Now, one of the things that I think most people believe in today, I would say those who believe otherwise are a tiny fraction of society, is that before you get married to somebody or decide you want to spend a long time with them, and maybe you're not going to get married to them, like Goldie Hawn and Kurt Russell, they've been together forever, they're still not married, but you're going to make that sort of a commitment. Okay? I think 98% of the population believes it's a heck of a good idea to find out whether you're sexually compatible before you pull the trigger on something like that, especially something like marriage, which is a legal matter. Well, sorry, if you live in the state of Oklahoma, nope. If you live in Oklahoma and you have sex out of wedlock, off to the hooskow you go. It's a crime. In Texas, if you own 6 or more dildos, yeah, I said that too, you're looking at a felony. Okay, help me understand where the legislature gets this authority. By the way, in the engineering booth, they are on the floor, I want you to know. And in Georgia, boy, Georgia is just, they're the worst. Sex toys, entirely banned. You cannot have sex toys in Georgia. Now, by the way, all of this explains why I live in Nevada. But help me understand where, the serious part of this, where a legislature could imagine that they have the authority to put you in a cage, take you away from your home, your work, your spouse, your kids, and put you in a cage because they said these things you shouldn't be doing. I don't think there's any justification for that at all under the law, but yet, as you can see, prevalent. And let's go on to something else, something a little bit more dramatic. Anal sex. And do you know there are still laws on the books? There was a case, Lawrence v. Texas, 2003 case, which struck down any laws against anal sex in private, no matter what the sex of the gender of the people were, between consenting adults. Okay? The Supreme Court struck that down. But yet, something like 13 states refused to remove those statutes. Well, why are those statutes there? Well, they're there to intimidate homosexuals. But a bigger point is, the basis for these laws is supposed to be something called the natural law. Let me share with you a definition. Natural law is a view that certain rights or values are inherent or are universally cognizable by virtue of human reason and human nature. Really, okay? Certain rights and values, okay, are universally cognizable. You know, I read this. This is supposed to be natural law. This is what a lot of these sex stuff, these sex laws are based on. Oh, the conformance with the natural law. Universally cognizable? I can't find anything that people are universally cognizable about. Okay, you know, if I said this is an iPhone, I'd find somebody who would say no, it's not. There's nothing that's universally cognizable. So this is a ridiculous concept. And when you're talking about the law and something, well, it's in accordance with the natural law, who gets to decide what is reasonable, what the natural law indicates? You? Me? Patrick in the engineering booth? I don't know. And the point is, there is no appropriate person to decide it except you. That's the liberty equation. And the idea that somebody can put you in jail because you made a call that's right for you, that some legislator disagrees with, even though you're harming no one, you're not interfering with anybody else's free exercise of their rights, you're going to be put in a cage. You see where I'm going with that? My friends, the immortal words of Thomas Paine: "It is the duty of the patriot to protect his country from its government." Thank you for spending what I know is your very valuable time with me. Talk to you next week. Take care. Bye-bye.